Good afternoon, everybody, and welcome to this afternoon's Lunch and Learn session. I will just give it a couple of minutes to see who's joining. And we are just here for half an hour this lunchtime. If we don't need all 30 minutes, we'll give the time back, but we will be a maximum of 30 minutes. We are covering things like terms and conditions today, main areas in a contract that you might focus on. And just while people are joining, I'll do a little bit of introduction and housekeeping. So you might have joined a Go for Growth webinar before, so you might know me already. My name is Gillian Askew, and I'm your host for today's Lunch and Learn session. This session is being recorded today, so a copy of the slides and a copy of the recording will be sent out to you probably within the next 24-48 hours. So please don't feel like you need to take lots of notes, but do whatever works best for you. As I said, we're going to cover things like main terms and conditions, some areas to focus on. It's not an exhaustive list, but we will be looking at things like warranties, liabilities, cost increases, termination clauses, intellectual property rights, etc. Just wanted to let everybody know, obviously today does not constitute legal advice. We're not procurement lawyers in Go for Growth, so we can't offer legal advice. But we are rather taking a practitioner's view and trying to give some pointers and things to think about, things to consider when you're looking at terms and conditions. We would always say that you should read a contract in full and try, if you can, to understand the responsibilities that contract will place on you as a supplier. And one of the things that you're trying to do with any contract in any sector, whether that's public sector or private sector, is thinking about if you fall foul of any of those clauses, what's the likely impact that could have, and what's the likelihood of those things happening. Today, the things that we're covering will be found typically in standard goods and services contracts. We're not covering specialist contracts like SaaS, software as a service, or any of the construction contracts such as NEC3. We would also say always, if you are unsure of any of the legal terms and conditions, always seek legal advice if you can. That can be quite challenging for smaller businesses. You might not have access to lawyers within your own organisation, but if you are a member of your local chambers, or if you're a member of the Federation of Small Businesses, for example, then you would have access to legal advice through those membership groups. There is always Citizens Advice Bureau, and if you do have questions, you can come to Go for Growth. We won't give you legal advice, but we can potentially try and link you with a legal firm where you might be able to get, often legal firms do an initial consultation free of charge before they work out whether they need to open a file, for example. So you can always come to Go for Growth. I'll talk to you more about how you get in touch with us. They're in the slide deck, all our contact details, etc. As always, we're on Zoom today, so there is a chat function and a Q&A function. Feel free to use both. I will keep an eye on both as we go through. We have got Q&A time set aside at the end, but please do feel free to ask anything as we go. If you want to say hi and introduce yourself, then please do feel free to do that on the chat function. If you are using chat, just make sure it's set to who you want to see it. So I think the options are everyone or hosts and panelists only, but if you are putting questions and if you want to pop those in the Q&A, that would be super helpful. So first set of key areas that we're going to look at, pricing clauses, including those mechanisms that are in place for increasing prices and costs where you need to. And it sounds really obvious, so forgive me, but a contracting authority, when they're setting pricing and budgets and values for contracts effectively, and when they're evaluating pricing effectively, what they're trying to work out is what's going to be the cost of this thing that we're procuring for the duration of the contract. Pricing clauses will give you a clear indication of how long pricing is applicable for and what mechanisms there are in place, if any, to levy increases. So, for example, some contracts might look for a contract duration price, a price that is fixed for the term of the contract. And there may be mechanisms in addition to that where you have the ability to levy increases linked to things like inflation. Or it might be annualized pricing, or there might be volume breaks on pricing. So there are different ways that pricing clauses are invoked in contracts, but it's really important for us to have a read through those things and think about actually what will the pricing look like for the duration of the contract. And not just the initial term, but including any extensions. And we're going to talk about extensions on the next slide. If you have any questions, and this is a common theme throughout all of the advice and guidance we ever give, if you have any questions at all, and in this case relating to pricing, but in relation to anything that we covered today, or indeed in relation to anything in a competitive process, you have something called the clarification question process, where you can ask through clarification any questions that you might have on pricing or anything else. And our advice would be to ask those questions as early as possible, because it might change how you represent yourself and certainly how you represent pricing in that competition. But those pricing clauses should give you an indication of how long your pricing is meant to last, what the mechanisms for increase are, and you can think about those things in relation to how you put your costings and pricing forward in that bid. So termination, obviously, one of the most important clauses. There are different types of termination, so I'm going to cover termination for cause first. So termination for cause, it does what it says on the tin. There is a reason why termination is being invoked. Those reasons why termination for cause can be invoked will be laid out in the contract documentation, but it's usually around a breach of contract of some sort, that especially a breach that has gone unrectified, or is of a serious enough magnitude that it would require immediate termination. If there are grounds for immediate termination, any of those grounds should be explained in the procurement document so that you understand what the conditions would need to look like for termination to be invoked. And there's also something called termination for convenience. Termination for convenience would allow, and usually with a notice period, generally speaking, the customer to withdraw for any reason from the contract. So you might see in a set of contract terms and conditions that the customer can terminate the contract for any reason, giving you a 3-month notice period. Often this clause is a one-way clause, and it's not an unlawful clause as we understand it, but it wouldn't necessarily be mutual. So, and when I say one way, that means the client might be able to invoke that termination for convenience clause, but you wouldn't have a mutual clause. So you wouldn't be able to terminate for convenience. As a provider, you might only be able to terminate for cause. For example, non-payment of goods and services. If you want to, through the clarification process, you can challenge the mutuality of the termination for convenience clause through that clarification process. And it's up to the contracting authority whether they are willing to change that termination for convenience clause to make it mutual. Or if not, you can also ask for the notice period to be extended to something that feels more relevant and proportionate to the contract value, the contract risk, and the impact it might have on you as a provider. And again, that's for consideration by the contracting authority, but you can ask them to have a look at that. You can also think about what the financial recompense might be for you should that client withdraw from the contract outside of any termination for cause. So outside of any breach of contract, they simply want to leave the contract. What's the financial recompense that you can expect? That should be laid out in the contract. If it's not, you can certainly ask a question about it. So we're talking about warranties and representations next. Obviously, warranties might apply to goods warranties, so they're usually being around fit for purpose. Also, that might apply to services, but think about the Sale of Goods Act, for example. But also you almost certainly will be asked to provide warranties and representations that you have the capacity and the authority and the capability to perform the contract, and that you have all of the necessary things in place in order to do so. So things like licenses, accreditations, authorizations, consents, etc. All of those things are in place. And the things that you need and you ask to warrant against or represent will be laid out for you in that contract document. And it's all about your ability to operate the contract. If you think something is disproportionate, it should be proportionate, relevant, and relative to the contract. If you think that they're disproportionate, or you wish the contracting authority to consider something else, then you should do that through the clarification question and process. Again, do that as early as possible. Often, what you're asked to provide warranties around is on a self-cleaning basis. So, or a self-certification basis. So basically, you will be asked to have in place by start of contract. You shouldn't necessarily be asked to have these things in place at time of bid, but that you either have them or will have them in place for start of contract should you be successful in order to operate the contract compliantly. So if, for example, an accreditation like Cyber Essentials Plus needs to be in place, or Cyber Essentials, or ISO 27001, the information assurance standard, those things you should be asked to provide a warranty on, that you will, if you haven't got them now at point of bid, that you would have them in place for whatever date that they say they need to be in place for. Often that will be contract start date or at a point in the future in the contract. So you'll be asking to provide a warranty against that. In terms of liabilities and indemnities, like most things, they will differ from contract to contract, but liabilities, again, fairly obviously, they look to lay out what each party is liable for. For example, it might say that no party is liable to the other for any indirect losses, loss of profits, turnover, or damage to goodwill. Again, and you can check with legal advice on this, but again, what you're thinking about is whether you're required to indemnify your customer against any of these things. Do you need insurance to cover any of these liabilities? You might have liquidated damages, unliquidated damages, unlimited liabilities. There should be less and less unlimited liability in contracts now, because it can often be a real barrier to entry. But you need to think about what those liabilities look like and what they might mean to you if they were ever at play, and how you might indemnify yourself against them, how you insure yourself against it. There is a note that death or personal injury due to negligence can never be excluded by either party in the contract. And we would say if TUPE is applicable, it's a very complicated and complex piece of legislation, especially where pension liability is concerned. And so if TUPE is at play, our advice would always be to get some specific legal advice or guidance on TUPE. It is a complicated piece of legislation. In terms of intellectual property rights, usually that's broken down into existing IPR or anything that's created during the course of the contract. Essentially, what you're trying to do is be clear on what you own outright before you go into the contract, and what you're taking into the contract, and what you are giving license to your customer to use, such as any data that you might gather through the life of the contract. Who owns that data? Who owns the content that you create as part of that contract? And also think about what you're granted license to use. So can you use your client's logo? Can you use their name? Can you use any of their trademarks? Are you allowing them to use your brand, your logo, your name, etc., etc.? And also, where IPR is concerned, it should be clear what happens to intellectual property on termination of the contract. If it doesn't, you should ask that question, because what you want to know is at the end of this, if we part company, I should be able to take out what I brought in because that was mine. And then you should know upfront, before you start the contract, what happens to any IPR that is created as part of that joint endeavour. Payment terms, most contracting authorities will have standard payment terms, but you might want to check if people are signed up to the prompt payment code, for example, so you can get a feel for what their payment history is like. You don't have to accept the payment terms necessarily, although it will be one of the things that you're asked to sign up to when you sign up to the terms and conditions. If you disagree with the payment terms that are being laid out, you can again ask about that during the clarification process window. Normal terms would be 30 days from date of invoice. What I would say is lots of public sector organisations do have shorter payment terms at play. So there are constructs like early settlement discounts, which require you to give a discount if they pay you early. But actually, post-COVID, lots of public sector organisations have shorter payment terms specifically for small to medium enterprise organisations, recognising that cash flow is really important in an organisation. And some of them that we've seen can be as short as 5 days. So it's worth inquiring as to whether those facilities exist if it's not mentioned in any of the documents. Payment of invoice will usually be conditional on having all of the correct information contained in the invoice and it being submitted in the right format to the right place. That might be electronic. You will almost always need a purchase order. Things like energy bills are usually different, but almost always for goods and services and works, a PO will be required for accurate invoicing. And it is the responsibility of the supplier to make sure that all of the information that's required is in that invoice and that you're sending it in the right way, in the right format, with the right information to the right place. And that will definitely give you the best chance at getting on-time payment, regardless of what the payment terms are. And on this one, finally, confidentiality. There will be data protection clauses. People will be thinking about the general data protection regs, but they'll also be thinking about confidentiality. So it is one to look at in terms of checking what you are and aren't allowed to do and say in connection with the contract, how you will treat confidential information. So you might be asked to sign a non-disclosure agreement or a confidentiality agreement separate to the terms and conditions. You might be required to keep confidential certain information pertaining in the contract, not just during the contract term, but beyond the life of that contract. So it's worth checking what the context and duration of confidentiality means and making sure that you've got the resources, the processes, the infrastructure in place to be able to deal with confidentiality. And that may well be, you might be working on redacted contracts, confidential contracts, or it might just be that you are joining a framework and you want to tell everyone about it, but it's worth double checking that there are no issues from a confidentiality perspective. There shouldn't be in terms of telling people that you've been awarded a contract, because there is a contract award notice process, but it is always worth, if you've got the business through a quotation or outside of a procurement competition process, it is definitely always worth checking whether you can talk about working with that customer, and especially if you're going to do that on social media or on the internet in some way, shape or form. And so if we move on to insurance levels, it will be specified in every particular bid what you need to have in place as a minimum insurance level. You'll be asked to have them in place for the contract start date. And the regulations are making it actually very clear that the duty is placed on the buyer to ask for those things to be in place at contract start, not at point of bid. You may well have to take out separate insurance policies specific to that particular contract. So you should only have to do that if you are successful in winning the contract. So usually the wording will be something like, agree that you either have or will have the following in place at contract start date. And it is about actually supporting bidders so that you're not having to pay for additional insurances until after you've been awarded the work. Those insurances will need to be in place throughout the life of the contract, and some may specify that you need insurance to be in place for a period after the contract. So check those things out, and it is your responsibility. The contracting authority may not check each year that they've got them, but it is your responsibility to have them in place for the duration of the contract and for whatever that period post-contract is. If for any reason that you think the insurance is either unnecessary or it's disproportionate, you can flag that through clarification. For example, if you are asked to have cyber insurance in place and you don't fully agree with or can see why you would need cyber insurance in place, then definitely ask that through the clarification process. In terms of data sharing and data processing, you might be a data processor, you might be sharing data between yourself and your client. Contracts will differ, again, as they do with lots of these things, but you might be asked to provide data processing, data protection, privacy policy type information. You might be asked to sign a specific data sharing agreement. It is a complex area, actually, data sharing, and whether you're a data processor, a sub-processor, if you're an information asset owner, and what the context of those things mean to you as a potential supplier to the public sector. Make sure that you do check that out. It might be one for specific legal advice around what's required. One of the basic things that you can do, though, is make sure that your privacy policy is up to date and that you understand your requirements to general data protection, and make sure that any policies that you have around data protection is both current and also visible. So usually you would have a link to your privacy policy on your website, something like that. But you can check those things straight away. If we think about media and publicity, again, usually there won't be an issue tagging your customer in social media or using their names in articles or advertising campaigns, but you should check that before you do it. So often clients are really happy to help their suppliers to grow and to create visibility and transparency in what they're doing. But also every organisation will have a tone of voice and a narrative that's really important to them. And there are some things to think about. So you will need to obviously think about the impact of what you're posting and whether that could have some negative connotation that could be linked to or interpreted to or by your customer. So if you're doing anything on media and publicity where you're tagging or using your client's name, always check that you have permission to do that. Sometimes if you're in a contract that you can't do it without express written consent. If that's what you need, then you should get those written consents. Or check whether that is separate to the core area of the contract or it's needed. So if it's the contract for advertising or PR, then you might be doing that all the time as part of the core substance of the contract. So it would be contract dependent, but do check what you're doing in terms of a media and publicity perspective if it's not a PR or advertising or media type contract especially. In terms of variation of contracts, so this speaks to how contract changes are made. It should be detailed in the contract. Any changes to specification, for example, might trigger pricing changes, and they can sometimes actually not be to your benefit, they could be to your detriment. And often in public sector, we'll talk about material changes and materiality. So a material change is something that's significant. And the way I tend to think about it is, if I make that change, would I have been letting a different contract? Would different bidders have taken part? So if a variation to a contract changes the contract value substantially, then it might have got more or less attention. Who knows? So there is that materiality element to it. Any variation process should be transparent to you. If the client is asking for a variation, you should be given time to consider that and to respond to that. It is likely that you'll be expected to try and make that happen if you can. Similarly, if you are asking for a variation, that process should be clear to you in the bidding documents, and you'll be following that variation process stipulated by your client. And again, your client will have a period of consideration. And again, it would be reasonable to think that they would try and accommodate a variation if it wasn't material and if it didn't affect the core substance of the contract. So if the variation was actually to the betterment of the outcomes, for example, it would be reasonable to think that a contracting authority would try and have a positive response to that. If in the unlikely event that bid documents don't include information on contract variation, you can ask for it during that clarification process, and we would always advise that you do. You should know before you go into a contract what you need to do if you need to change it, and what your client would do if they want to change it, and what happens if you decline a contract variation request from your client, etc. And contract extensions, so often frameworks and contracts are let with a core term with some additional extensions. So for example, a 4-year framework or contract might be on a 2+1+1 basis. And what that means is the core term is for 2 years, and then you have 2 separate 1-year extensions. So it's worth understanding how extensions will be invoked at the point of bid, as often, and we find this in Go for Growth, often internal processes can change for the approval of a contract extension during that initial term. And you're only guaranteed the initial term, and the extensions are therefore not guaranteed. So your customer doesn't have to invoke the extension if they don't want to. So it's worth understanding before you get into the contract what the conditions for those extensions being invoked are, and what happens if they change internally. Where does that leave you as an organisation? Again, it should be clear in the contract documents what that process is, but it will tell you what the extension is, but it might not tell you how it's invoked. So I think it's worth asking for that. And also, just as a reminder, where there are indications of volumes of work, they may or may not be guaranteed. So there might be minimum volumes, there might be maximum volumes, and there might be no guarantees around those volumes. So it's worth understanding that as well, both for the core contract term and for extensions. And in terms of dispute resolution and law jurisdiction detail, this is about how issues will be dealt with if you end up in mediation, for example, and under what legislation applies. So it should be UK law, and jurisdiction would be English courts, for example. Make sure you're happy with that. Make sure you're happy with what the arbitration process would look like after a period of good faith attempts, example, to resolve issues. And make sure you're happy with the timescales for escalation, because they should also be quoted. And I know that was a whistle-stop tour. So the last thing really to say before we've got a couple of minutes for questions is we know that this can feel really tough and fairly lonely and an isolating place to be when you're bidding. Help is on hand. Go for Growth has no charge to suppliers coming to us for support. As legal terms and conditions go, as I said, we're not procurement lawyers, but we can help you with practical advice and guidance, and we can always point you in the right direction of legal firms if that's helpful. Our contact details are on there, and in our video library there's lots of skills-based workshops and tutorials on there that could be helpful for other things as well. And if you would like to, please do feel free to stay in touch with us. You can join our mailing list. Typically, we'll talk to you about opportunities that are coming up in the public sector or private sector. We don't send you holiday snaps and details of what we're eating or anything like that. So, and you can also obviously opt out at any time. And that was everything that I wanted to cover today. So we have got a couple of minutes left. I will just see if there are any questions in the Q&A, and I'll stop sharing the slides. So we've got nothing in the chat or in the Q&A as it stands at the minute. If you think of anything after the event and do want to have a chat with us, please do feel free to get in touch. Hopefully what we've covered today, although it's quite high level, hopefully it's been useful and helpful. But Go for Growth is here to help at any time, so please do get in touch if you need us. If there isn't anything else, thank you for that comment. I'm glad it was informative. If you need anything else, give us a shout. But in the meantime, have a really good rest of your Wednesday. We have got one final Lunch and Learn session coming up next week on the 27th, which is about the feedback process. So what happens at the end of the competitive process? So if you'd like to come along to that, be another half an hour where we cover off what it means to be a winner or a loser and how you'll get your feedback and what that feedback should look like. So feel free to join us for that one, and have a good rest of your Wednesday. Thank you.